Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Brown versus Cara. This case was heard in the Second Circuit Court of Appeals in the year of 2005. Let's go ahead and jump into the facts of the case. So Cara was a business owner. He owned a business called Track Co. And this business owned a nice piece of property in New York on J Street. This property was unique in that it was a parking lot. So it couldn't be used for much other than parking cars. But Brown, the plaintiff in this case, and Cara kind of got together and they discussed, this property could be worth a lot more if we could get this rezoned and put maybe a commercial building on here or a residential building. We could make this property worth a lot more than it currently is. So Brown was like a connected, social dude, and he said that he had the connections to get this rezoned. He could go lobby city council, get this rezoned, and then we could, the two of them could put a large commercial or residential building on that property. So Cara's like, sounds good to me. I mean, I could increase the value of my J Street property. Brown is like, this is sweet for me. I'll get some money out of this deal. And so they decide that, hey, let's work together. So the attorneys draft up a memorandum of understanding. In this memorandum of understanding, it just basically says that the two will work together to develop, build, and manage a new real estate venture on J Street. So very broad, doesn't elaborate many terms, but it does, kind of say, hey, the two individuals are going to work together to try and rezone this property and develop some real estate on it. So Brown, with this memorandum of understanding, says, all right, it's time for me to get to work. I'm going to try and work to get this rezoned. I'm going to develop, an architectural plan. I'm going to work. And the negotiations go back and forth a little bit more. And eventually Brown sends, what's supposed to be a final negotiation to Cara. Cara gets offended by it. They don't say why in the decision, but likely because the amount of money Cara was going to get was too low and he got offended by it, right? So Cara says, you know what, Brown, I'm just done with you, man. We're not doing anything with J Street. It's going to stay as a parking lot. You offended me. I'm out. I'm done. Like as Mark Cuban would say in Shark Tank, for that reason, he's out. So Cara's out. And Brown is so frustrated with this. He's like, we had a memorandum of understanding. We had a deal that we were going to work together to develop this property. I incurred substantial costs by, developing this architectural plan, trying to get it rezoned. This cost me money and time, and now it's all for naught. It's just a sunk cost. It's not fair to me. So Brown brings suit. What he's trying to do is enforce the memorandum of understanding as an agreement prior to the contract to try and get something out of Cara. So the court in this decision delineates two very different types of preliminary agreements: a type 1 preliminary agreement and a type 2 preliminary agreement. Court says a type 1 preliminary agreement is one where all of the essential terms of the contract are agreed to. So this envision a deal where you're going to buy the house. Literally, everyone's good with it. It's all done. Everyone agrees to the price. We just have to ink the final deals, which might say, hey, I want you to rip that tree out, or hey, I want you to just take off the sticker of this wall. So all the essential terms are agreed to, but there's, some small terms that aren't agreed to. But the court says that in that case, the preliminary agreement is binding. The court does say that these are much more rare than the type of agreement that the court now describes as a type 2 preliminary agreement. A type 2 preliminary agreement does have some agreed to terms, but it doesn't have all of the terms agreed to. So the court says that the memorandum of understanding, the original document that Brown and Cara worked out saying they were going to work together to develop J Street, falls under a type 2 preliminary agreement. A type 2 preliminary agreement doesn't have the force of law like a type 1 agreement would, but it does have force of law on agreed to terms. So the court says there's an agreed to term in this MOU, memorandum of understanding. The agreed to term in the MOU is that the two parties will work together to try and develop J Street. So the court rules that, this is binding in a sense. The MOU is a type 2 agreement. And hey, Cara, you got to work in good faith with Brown to develop this property. So that's the case. The most important part of the case is the delineation between type 1 and type 2 agreements. There's some tests that you'd want to look to in the actual text of the case. There's 4 factors for each one. I won't go over that here, but it is in the case. Yeah, so the type 1, type 2 agreement is the most important thing to glean from that. The ex ante implications of this case are a little bit interesting. The court ruling for these two individuals to act in good faith, does that mean anything? Are they going to do anything? Is Cara going to do anything? Right? If someone told me that there's this guy that really has offended me, right? Brown has offended Cara. They don't like each other anymore. And if someone said, hey, this individual that's really offended you, now you have to work in good faith with them. Well, I would say, yeah, it's my good faith effort. I tried to work with them. I'm done. I'm not working. In good faith, I tried. Good faith is such an abstract term. It's hard to define that, right? So what weight or bearing does this ruling even have? What weight or bearing does the MOU even really have? It's a good question. Well, the court doesn't lay out what good faith means. It just says that Cara has to work in good faith with Brown to develop the property. So not a whole lot of meat coming out of the ruling or of the MOU. It's interesting that the court saw fit to try and rule that the two parties have to work together rather than just say, hey guys, it might be more efficient for you two to just lick your wounds and go away. Just lick your wounds and be done. You don't have to work together in good faith. Maybe award Brown some nominal costs for the work that he had done to, create an architectural plan, or for the work that he had done to try and get it rezoned. Maybe it doesn't need to be a large sum of money, but maybe let's just give him some small sum of money for that. You two can lick your wounds and get on. I think that would be the more economically efficient approach, rather than forcing two parties that don't really want to work together to try and work together, because the bargaining costs in those types of events are going to be so high that the overall transaction value is going to be too high, and it won't be efficient for the economy. So something to think about there. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a great rest of your day. Bye-bye.